Hey there, Stephanie Joy with All Things Social Security and the Law Practice of Joy Disability. Here's a short little segment from our recent live stream Q&A that we have every Wednesday at 1 p.m. Eastern Standard Time on the YouTube channel, All Things Social Security. Enjoy, and if you have any questions, leave them down below in the comments and I will be sure to get to them. Thanks so much. Bye-bye now. Hey, how are we doing today? People are just starting to pop in. I hope everyone's doing great. Hope you had a great week. It's only Wednesday, but half the week anyway. For most people anyway. Everything is good on this end. Busy, busy, busy as always. Candy Brown is in the house. Hi, Candy. I don't know that we've met. I have ALJ hearing in July. Do not have attorney. Do I need one? Had one when first denied. What happened to your attorney? That's a shame. I always think you want to have one, but oops. Unless you know everything you're doing and you can do all the things he would tell you, but it's really up to you. But sometimes they're hard to get at this late stage, so you might be on your own, but you can try if that's what you want to do. I'm curious what happened to the first one. Jemmy says, yes, you didn't remember the exact last dates in 2019. I didn't remember the last dates in 2019. Pardon me, I'm just reaching for my water. But I've already told them that there was some unsuccessful work attempt. Guys, that's the same thing as a failed work attempt if you see FWA. Because I crossed, I don't know what that means, to my therapist a few times. Took a month, long break. Gotcha. So the UWAs, the unsuccessful work attempts, would have given you an opportunity to assert an earlier alleged onset date, potentially earlier than that, June of 19. I mean, that is something before you're kind of the eve of hearing now. This probably won't work for you now, but sometimes those things don't arise. We don't even know about them until it's close to hearing. Not this close, but because we'll get something like the detailed earnings report that we don't have any access to until the Office of Hearings Operations produces it and puts it in the file. So the SSA never puts it in, the OHO does. Sometimes that'll crop up stuff and you'll see work that nobody knew about or mentioned. But it might be cause for adjusting figuring out there was actually 3 jobs that made up that amount, and there was 2 months in between this job and this job. That last one could be an unsuccessful work attempt. And then we'll say, can we do an amended onset, Judge? Because blah, blah, blah. Assuming we have the medical records that would suggest that it could happen. You never know if they're going to find out that way. You don't want to assert it if it's not reasonable. Like if you know you didn't treat it all, I'm talking to everybody else, not you, Jimmy, then why are you putting that date? It's not going to work. June 10th, 2023. Okay. You have all those records between 2019. You got like 4 years worth of records that are able to be considered to prove the actual onset stuff before then. The old stuff is historical, not unimportant, but not any that can be relied upon in and of themselves. The crumbs on top of it to help build that cake of getting that award. Our Dade says, also my claim is at the process center and they said this is the fastest they've ever seen. They can't give me amount of payment yet. Let me just see. That's awesome. I'm glad you went quickly. That's super. Less stress. Hey, Elliot's in the house. Elliot is here, but maybe not for long. Sorry I'm late. No worries. Hope you're doing well, Elliot. Michael, oath out. Michael, just call you Michael for now. Hi, Michael. I was talking to our Dade. I shouldn't interrupt. Yeah, I'm going to say one thing about workers' comp and SSDI. Workers' comp can completely make I can't stand workers' comp for disabled people, by and large, because it makes it so much harder for a disabled person who's been knocked out of being able to work any kind of substantial gainful job from getting any treatment. They control it. I think every state is a little different. Some states more so than others, but it's like they'll say, no, you're not going to that physical therapy. We're not paying for that. And you're not allowed to go. They will even say, I believe, that if you go on your own, we could just cancel your case. So it's like they own you. It's horrible. I don't think it's right. I think they could do much better with those laws. You can't even see your private doctor for anything that's of the workers' comp injury. You have to see their doctors. If your private doctor is like, my gosh, you've got that big wound, and they won't let you get wound care. I'm being exaggerating here. But like, and the doctors, that's why when you go in and see a doctor, you'll often say, is this a work-related injury situation? Or it'll say, is this car accident related? Have you guys seen that? And that's because if it is car accident, depending on your state, I suppose, injuries from car accidents have to be paid through the car insurance. Injuries through workers' comp have to be paid through the workers' comp insurance. Now, for the car business, you can treat with your own doctors generally. And I'm speaking really from my history with doing insurance defense work with New Jersey back in the day. That was where I got my litigation feet on, trials and such. But that doesn't own you of where you go, I don't think. Or at least not to the same degree. Workers' comp owns you from the second you make the claim, and They control what you get, and then your doctors can't treat you, and they'll say that's why they ask that question. They'll say, "Oh, we can't treat you. You'll have to go through your workers' comp," and they'll tell you who to go to. And that's really disturbing to me. And I've seen people who should have physical therapy not have it. It's like delayed like 9 months, and now they've healed incorrectly. So can you tell I'm not a fan? Cecil says he's in his will have to have a chaperone. We already did this, right? Did I pop up? Our date is third time of what? Applying, but I'm the 100% PNT vet that's under 50 apply for SSDI. Yeah, it's not easy, right? Kathy Clayton says yes, case pending. Wow, and you can see your estimate still. That's interesting, Kathy. Very interesting. It's not there, but you made a cut. So you're talking about your old estimate. Yeah, not new. Okay, before you applied, is that what you're saying? Let's see. All right, so Cecil's talking about a young person with autism and other significant disabilities, was diagnosed at 3 years old, saw one therapist at 16 or 18, I believe, and they put him on disability from his deceased dad. So he had to have treating providers before that. Like if he had severe problems, he would have been having treating providers, right? So there's got to be more. Yes. All right. So I'm sorry. So we were miscommunicating, Kathy. I thought you were saying you could still see it. And I'm like, no, wow, that's so cool. Maybe they're changing it. Yeah, you got to get it before you click the trigger for applying, guys, if you want to get your estimate of what your benefit will be. Otherwise, it will disappear. You can always get your earnings, though. That part of that report will always be available. So that's really important, particularly if you need to know your DLI. Is there anything else I need to tell them to have besides a journal in case there is a review? I don't know. Oh, I would have to think long and hard on it. It's not something that necessarily pops in my head. I was just thinking out loud when we were talking about this. In case there's a review, I don't know if they have the old paperwork. Their house got broken into and destroyed. Ooh, that is tough when people get rid of stuff or, toss it because it got broken into or there was a flood. Yeah. It makes it harder. But he's already collecting benefits. The pathetic part is, if he's already collecting benefits, the SSA already had his full medical workup, all of his records. That fellow on here, JC, a month ago or whatever it was, had been denied, and the ALJ even regretfully denied him because felt like he had to do that. The guy had been on SSI the whole time, and now he can't get DAC because the records that the SSA had 20 years ago, say, that got him the SSI when he was 18. Well, we lost those. We don't have those records anymore. So you got to produce records of when you're 18. The fact that they found him disabled should have just covered it. Res judicata, collateral estoppel, you name it. And that's what I got to look up because I know there was a recent ruling in the last several months about collateral estoppel, and I think there a better recognition of it. It just is so unfair. It is so unfair that this person has to remain on SSI when his parent paid for DAC and he would be eligible for DAC. By proof-wise. Cecil says, oops, yeah. Sorry, Cecil, I was about to repeat your question. Michael says, I got an overpayment letter for being over SGA, but I have filed an appeal and have provided with a second copy of pay stubs, all earmarked when they messed up. What are my chances of winning? If you did not work SGA and your pay stubs prove it, I think you have a very good chance of winning. Often not at the field office level, though. Sometimes I'd say you have to go all the way to ALJ. Because they just don't pay attention so much down there. But then you just continue and go to the ALJ and have your stuff organized and respectful. And by the time you get to ALJ, you're going to want to get the file. The OHO can give it to you, certainly by then. Because what was it that they were relying on that made them think you were SGI? Like you're thinking it was your pay stubs and you're showing them, but it wasn't. What if they had some other reportings that you earned money at a second job and that put you over? That's what you're going to want to make sure you know so you can then prove that wasn't true. T Cash says, yes, my sister is on SSDI for 40 years, and when I log into her portal, it doesn't say anything about the letter. It still says active. Could this letter have been a scam? Well, scams do, but I don't know what they have to gain from it. Do they say, go to this link? You got to call the SSA. Are you her rep payee? If not, then you keep her with you and you both call together. You need to find that out. You need to find out because the portal messaging is not necessarily up to date. Sometimes it's outdated and things have changed since. So get on it right away. T-Cash would be my recommendation. John Lantieri in the house. Quick question. How long is the wait time after your mental health evaluation? Hi, John. Nice to see you. Historically, typically, it always seemed that after CE's decisions came down within a couple weeks. See variations sometimes now if something big medically gets advised to the adjudicator, like, but wait, there's a surgery. Then they might be like, okay, now we gotta wait because we want to see what's going on. But usually it's usually the sign that it's the end because remember they only do the CE after they've learned that there's not enough evidence, like if it's a mental state, there's not enough treating records to define what those mental limitations are. Incidentally, guys, if they ever ask you, like an adjudicator says, like, let's say you alluded to anxiety and depression and stuff like that, but you're not treating. I just had this happen. This is why I say this. I spoke to the adjudicator about it. And they say, well, want to know if the mental limitations prevent work. Well, that's a legal conclusion, first of all. And I said to her, and this is a person in their 50s, and I said, actually, the question isn't whether that anxiety and depression that's very distracting and, and the little memory distractions prevent all the jobs in the economy. It's whether or not it contributes to taking away some of them or her prior job. So if her prior job was skilled, which it was, then that with those alleged concentration and focus problems, could she still do that brain surgery on a dime? She might be able to do a million other jobs, but could she do that one? And the reason why that's important is because it's someone in their 50s. If she can't do that prior brain surgeon job because of that distraction, we just met prong number 2. And that's for mental health treatment for even minor mental limitations that do not interfere with your ability to do your banking or go to the grocery store, but they do interfere with some of those higher skilled things. If you were a higher skilled earner, can totally get you prong number 2, which you could have been, can be the prong that you would lose under. So those CE, I wanted to bring that up because if they ask you, does it prevent work? Someone who doesn't know what this is supposed to mean might say, well, I mean, my back prevents work. Now an adjudicator who doesn't know what they're doing or is ill-spirited might say, we're not following up on the mental because she just totally told me it doesn't affect work. Well, now depends what your definition of work is. It's really 12,000 jobs. And I'm sure that affects some of those jobs, like that brain surgeon job. Another example of that just happened last week. Something that happened, this is now a couple years ago, but it was a hearing impairment. And the adjudicator called my client directly, which is a no-no to me. And that gets my feathers ruffled and my mama bear comes out. So I reached out to the adjudicator and I told her firmly but calmly, as per my intake letters, you're not to call my client directly. You go through me. Well, it was about the hearing. Oh, I know what it was about. I said, from the audiology report that the hearing is reduced or that there were complaints of hearing and maybe she needs an audiology. And she said, and I think she had asked the client this and the client had told me this. Well, did the hearing stop your prior job? Did it stop you from working? Well, that's not the end-all answer either, because if the hearing isn't the thing that stopped you from your prior job, but it was your bad back, again, the hearing is going to stop every job that requires very good acute hearing, discernment from hearing. So when they try to pull this stuff, I don't know that they're even allowed to do that. Maybe it's because she wants to rush through the case faster, get it off to the next step. So that's one less in her quicker. I don't know. But this is why I'm always like, if you have an attorney, the attorney should be taking those calls, And I always say to my people, let it go to voicemail. Don't ever answer the phone for the SSA or the DDS or even the OHO. Get me the message and I'll call them. And it's not actually overwhelming to do from my point of view because they don't do that often. A lot of times they'll call and not leave a message. And I'm like, that's interesting. Why don't they leave her a message? Oh, because they wanted to get her and get stuff from her out of her mouth, which is always so twisted and convoluted and confusing. And they can ask it in a way that will get the wrong answer. It'll get an answer that will lead them to a bad result. Not all adjudicators do this. I don't think it's right. And particularly if the lawyer said, you're not to call my client without my permission. And then my permission's always no. There are rare occasions when they need to call about scheduling a CE or the field office when they're early on. We're trying to just get everything on feet because they're not going to listen to me because I'm not yet connected. But other than that, it's like all night. It's not even staff. Hit the like button. Thank you, Cecil. I roll. By the way, we're almost 2.5 hours in, guys. We always go overtime. We start out slow, but then, but I think we're getting close to the end. Yeah, it froze. I roll. I know. It came back. Thank God it didn't last long. It said something about connectivity. I think that happens with heat. I'm wondering what it is out there. We've had a real heat splurge up here. Candy, something was withdrawn. The attorney backed out, or you terminated him, or because either side can do it. Of course, everyone has the right. All right, thanks, guys. Have a great one. Be safe.